Right, so hopefully everyone can see the opening slide saying Introduction to Work Health and Safety for Volunteers. What I'm going to do is take you on a bit of a cook's tour of that today. In doing so, got to bear in mind this is a big topic, and I've tried to throw in some things that are relevant for volunteers, but it's really too huge to do it in an hour. Probably too huge to do in a day. There's so many nooks and crannies to it all. So this is very much a broad overview to get to sort of familiarise yourselves with the general concepts in work health and safety, and sort of like have you thinking a little bit about your own business, your own associations, and whether you're coming up to scratch with regard to the regulatory requirements. So in Queensland, we're governed by the Work Health and Safety Act 2011. Now, this is the latest version of a number of acts that go back to the 1990s. And this version is also part of a national scheme. As I said, in the 1990s, the various states saw a need for safety, start regulating safety in the workplace because of a number of big industrial actions. So, industrial accidents. So, for instance, in Queensland, right outside my window where I work now at the Commonwealth Bank building in Queen Street, there was a 1989 horrific accident where people got crushed by building materials that fell off the side of this building when it's been constructed, and that prompted the introduction of the original Workplace Health and Safety Act back in 1989. We now have a national scheme. The reason we have a national scheme is to try and make it uniform, so everyone knows when they're working across state lines that they'll by and large have the same rules apply to them. Of course, Australia being Australia, every state thinks that they've got their own idea of how the best to word the national scheme. So there are some slight differences in wording, but the concepts by and large are the same from state to state to state. There are still some states that have not bought in. Western Australia only joined the national scheme at the end of last year, pending the result of an election, and then after the government won the election, they've introduced the legislation in the last few months. So as I said, it's a national scheme. There are general broad concepts that you've got to get your head around, and I've listed there. Firstly, you've got to think about who are the people who owe duties to under the Work Health and Safety Act. What is the scope of their duties, and how can they discharge that duty? That is, how can you satisfy the statutory requirements? And I'll talk briefly what happens when accidents happen, as I say, but when things go wrong and there is the potential for some action from a breach of a duty. So, looking at who owes duties. As I said, the legislation is designed to be broad. It's designed to really cover any type of workplace event or incident, and everyone who might be involved in a workplace event or incident. So it's deliberately avoiding specificity in its description of the duties and who owes them. So it's going to say, here's a big bundle of people who we think might be involved in workplace accidents. The first one is, and this is a key term that we use, PCBU, which is a person carrying on a business or undertaking. Now, when it says person, it doesn't mean a human being. It means the legal entity. And that legal entity can be a corporation. It can be an association incorporated under the Associations and Corporations Act in Queensland, or it can be an unincorporated association. That is a group of people who come together and operate as a collective charitable organisation. They are each in themselves a person. So the company's a person, the association's a person, the committee of people who form the unincorporated association, they're a person. They're each a person for the purposes of the Act. So they each will be a PCBU. The Act excludes unincorporated associations per se because they're not a legal entity, but the members of that unincorporated association, they're all human beings and they are recognised as legal entity, legal persons, and so that's where the legal liability can apply. The next thing is workers, which is another important defined term under the legislation. So a worker is not, as you would think, just people who turn up to the office and get paid. It means anyone who's engaged in the tasks of carrying out work for the PCBU. So that includes, obviously, people who get paid. It includes labour hire workers, and it includes people like volunteers, which is important from your situation. It also includes the contractors and their employees who might come and do work for your associations or PCBUs, I should probably use the term. So so you can see it's a broad range of anyone down below who's doing something for the PCBU or association. They will be regarded as a worker. That's important in two fronts. One is what you owe the duty to, who you owe the duty to, and also they'll owe duties in their own rights. Next, you have officers, and I'll talk about that in the next slide, but officers is a very important concept. They're not the worker bees per se, they're the people up the top of management who make the decisions on what happens down below. And officers will be seen as being the heart and mind of the PCBU. So you've got the entity itself, but that if it's a company or an incorporated association, that's just a artificial legal entity. They look behind that veil to see who are the people actually in charge of it, and those people actually in charge of it will be the officers. And lastly, and often people don't consider this, anyone who's at the PCBU's business or premises, sorry, I shouldn't say business because if you're volunteers, you're not a business, but anyone at the premises can owe a duty to others. So just because you're not a worker and you're not part of the PCBU doesn't mean you don't owe duties to other people. So literally anyone walking off the street, but it can also be punters, it can be patients, it can be people receiving the benefits of the association. They will owe duties to other people, and that's often overlooked in the whole process. So people often think, well, it only relates to the business or undertaking. It doesn't relate to anyone outside of that, although it's fairly rare, I should say. As I said, officers are not unusual. They're in a unique position under the legislation. So whereas normally the legislation is looking at what someone does directly to maybe injure or cause harm or create a hazard to others, officers' duty is not that they've directly caused it, but that they sit in a chain of responsibility where their knowledge or power or authority means that they could have taken steps that would have prevented someone else injuring or causing harm to, or putting someone else in danger. So the definition of officers it's very much a secondary duty. You're a backup, or you're looking further along the chain. So that and this is a very important part for workplace health and safety, because you'll often find if an accident occurs, Work Health Safety Queensland will always look at who are the officers of the association, or the PCBU, sorry, to see if those officers, first of all, identify who they are, and also then look at, did those officers know of, or should they have known of, the risk of injury to the person who got hurt or killed even. So that this is a thing you're always going to have in your mind. If your charity is set up by way of being a corporation or an incorporated association, then I'll be the directors and officers of that organisation. They do have a backup also for persons who are not on the book, so to speak, as the official office holders, but they sit in the shadows. We call them shadows. Shadow directors. They're people who effectively make decisions, and on the evidence it shows that they control the decision-making process, even though their names might not be on the roll. as the official directors or office holders of the association. So this will often arise where you'll have a board or a committee which may make the decisions, but they frequently defer decision making to some other person within the organisation who effectively is the power behind the throne that tells everyone what to do or is consulted regularly on what to do. So, because as we'll talk about later on duties, the duty of the officer is really how did you exercise your authority or control? And if the committee just says, well, I just followed Bill Smith's directions, Bill Smith can't then dodge responsibility by not being on the board. The other thing to have in mind when you're dealing with legislation, we often think of, I'm one person, therefore I must only hold responsibility on one basis in the accident because so I'm the officer, or I was the worker, or I was the supervisor, or so on. That's the wrong way to approach the Work Health and Safety Act. The Work Health and Safety Act, probably less than volunteering, but certainly still a valid point, that the Act lists a whole range of duties in a whole lot of different capacities. You can have multiple people owing the same duty in the one event. So you might say A, B, and C and D may all owe the duties, even though only one person's actually caused the accident. But you've got the supervisor, then you've got the manager, then you've got the officer. You can also have the case of one person may owe multiple duties in different capacities. So especially in small organisations, you might have the person who's in charge of the whole operation is also the one who's been the person carrying out the actions that may have caused the risk or hazard. So not only are they liable in the capacity of being in charge as an officer and having therefore authority over what happened, they directly caused the event. They can also, in some cases, be the person who's in charge of dangerous equipment. So they owe a duty not only as a worker, possibly, but also as a different duty as the person in charge of dangerous plant and equipment that we'll come to discuss a little bit later on. So it's important to wrap your head around the fact that it's not just, you may not get shot just for one capacity, you might get shot for a couple of different capacities, which will multiply the amount of penalties that might be imposed upon you, and you just can't think I will only have to apply the worker's duty. You might have to apply other duties in addition to that, although there is a certain overlap, as you'll see, in what the duties actually are. All right, which brings us neatly to the idea of scope of duties, which is, now that you know you're liable for a duty, what exactly is it that you're meant to be doing? And as I've said, it's designed deliberately to be vague. So what you're being asked to do is, so far as, and you'll see this term, I'll come to in later on, but the word reasonably practicable. So far as reasonably practicable, you'll make sure that everyone's healthy and safety. That has to do anything with the PCBU. So that means for the workers engaged by the PCBU, the workers carrying out work for the PCBU, because as I said, that could be someone outside of the PCBU, like contractors or labour hire staff, and anyone who might be affected by the work carried out by the PCBU. So that means your own people, anyone you got in to help you out, and whoever is going to be the recipients or even bystanders, as in the case of the equipment falling off the side of the building here. And that's the duty imposed on the PCBU. That's got normally the first port of call if there's an accident where the work health and safety is going to look at. They're going to say, did the PCBU do what it was meant to do in protecting the health and safety of others? There are some secondary duties as well. I've limited the ones at the top that would be most appropriate for your types of associations, because there are a lot of ones they're talking about electricity and noxious gases and dangerous plant and equipment, incorporating dangerous plant and equipment, importing, supplying, repairing and maintaining. So that sort of stuff I would not expect to be part of your association's activities. But what you can find is that the PCBU can be liable not just to ensure the safety of everyone, but there's another duty that says, as an occupier of a workplace, not a residence, but I wouldn't expect you, and by residence I mean your personal residence, not if your association actually runs a residence for other people, such as a nursing home and the like, it would still be a workplace, and so you don't get the exclusion for residences. But if you're the occupier of a workplace, you've got a duty for everyone who comes onto that workplace, whether they're worker, contractor, others, to have safe access and exit, and also to be able to travel safely around the place. So less for you guys, but I often get cases involving warehouses where the forklifts are zipping around all over the place, and occasionally they tend to hit people. And the first question we always look at is, are there dedicated pedestrian walkways within the warehouse where the forklifts know not to drive? Is there signage? Is there speed limits, etc.? So is it, if you own a building as part of your association's work, you've got to be aware that you've got a second duty, just simply by virtue of using those premises, to make sure that those premises are safe. The same thing is if you're using any what's called fixtures, fittings, or plants, that is any equipment as part of your association, you've got a duty to make sure that that equipment is safe. That's probably outside your own personal expertise, but you've got no obligation to make sure that you engage experts who can ensure that those fixtures, fittings, and equipment is safe for people to use as part of your work as a PCBU. I then go and quickly look at officers of PCBUs. Like I said, officers are the heart and mind of the PCBU. So their duty is very similar to the reasonably practicable duty of a PCBU. They use the words due diligence because due diligence is a common phrase that we use when we talk about officers of companies. But due diligence essentially means that you're being reasonably practicable with respect to the transfer of information up the chain of command and the issuing of orders down the chain of command, so that the people at the top know what's going on and the people down the bottom know what they're meant to do, because there's been this transfer of information up and down. And when Work Health and Safety come and have a look at it after an incident, they'll certainly look at what was the chain of command, how was the information about work health and safety risks down the bottom transmitted up to the people who actually had the power to do something about it. Now, I've included in there, it's a peculiarity of the legislation. If you're a volunteer officer, that is, you're a member of the board or committee, and you're just doing it on a purely voluntary basis, you're excluded from legislation because it's considered that you're just doing this on a philanthropic basis, and it'd be wrong to impose on you the onerous duties of being an officer, which is being akin to a director of a company. If you're not a volunteer, that is, you're a paid officer of the association, then you will be caught. And I've said in there about non-volunteer officers for unincorporated associations. For workers, so workers are a duty on twofold, not only for their own personal safety, but for the safety of others. So you can actually get breached for injuring yourself, which is a tragic thing for someone who may have caused significant injuries to themselves, which has occurred, unfortunately. But you've also obviously got a duty to not hurt other people. And that ties back to the reasonably practicable test again, which we'll discuss later on. But it's important for workers to realise that they just because they're down the bottom of the food chain, so to speak, that they're somehow avoiding any liability if an accident happens. They can be prosecuted, and again, forklifts is a red hot topic at the moment, but probably less for you guys. But a lot of forklift drivers get closely examined whenever there's an accident around a warehouse, etc. And lastly, there's, as I said, others. So just because you're not part of the association doesn't mean you can't get pinged if your actions have directly caused injuries in a workplace. So this will be people who come in and somehow caused some injury to some person through some means, but they're actually not part of the PCBU. As I noted, volunteers are specifically included as both for liability, both as a worker and as an other situations. So by way of an example, years ago, there was a matter I was acting for an entity which was involved with a charitable organisation. They arranged for volunteers to go, so entity A arranged for volunteers to go work for the charitable association, who were then supervised by another charitable association to do work on a very large field, that was a playing field area. And as part of the process, there was a tractor there pulling a trailer. The trailer was meant to have all the plant and soil and that for doing the gardening work around the field. But instead, two blokes decided to hop in the back of the trailer and go for a ride as the tractor pulled them across the field. Unfortunately, the tractor jerked as they took off. One of the guys fell off the back of the truck and a trailer, and landed on their head and unfortunately died from brain injuries. In that case, Work Health and Safety held liable the entity that organised the people to go out to this charitable organisation, the driver of the tractor, who was a volunteer, who was just there doing work on the day, the voluntary association who was meant to be supervising the workers, and the voluntary association who was receiving the benefit of the work being done by these people who'd come out to do the horticultural work. So you can see that the scope of duties can catch up a whole lot of different persons in different roles, the volunteer going out to run the tractor on the day would not have had in their mind that they could possibly be prosecuted for driving the tractor, or the entity, my client, who was the entity that actually placed the volunteers with the association that was actually going out to do the good deed at the grounds. So as I said, you really got to turn your mind. What role am I sitting in? Am I sitting as a worker? Am I sitting as another? Am I sitting as an officer? Or am I sitting as a PCBU? And just before we pass off scope of duties, I just want to go very hot topic sort of things for duties these days. And I've done a talk on COVID. Talk about scope of duties with work environment, plant and equipment, system of work, all the things that you'd normally think would be causing potential injuries to people. I've mentioned down there, which is at the bottom, which is often overlooked, the need for information, training, instruction, and supervision. And we'll come to that later on when we talk about the paper trail that you've got to establish. But people often, as in that case about the tractor, people just turn up and don't bother to think about giving a briefing before starting work, or making sure that people are actually qualified to operate tractors, or the like. And the level of supervision, as I said, the monitoring is always a key issue that they'll look at. Work Health and Safety will look at. I said I'd love to be able to go into the detail, but we've got to keep the track moving, so to speak. It's just so broad. There's just so many factors to take into consideration for work health and safety, and of course, it's always the ones that you forget about that catches you out at the end. And look, I just wanted to go hot topic these days. So it's become less of a topic now, COVID-19 protocols, but for the last 2-ish years, pretty much since April 2020 onwards, work health and safety practices like mine, we had a field day with people coming in saying, what do we do about COVID-19? Are we caught? Should we do, what are our obligations, etc. That's become less of a hot topic as the government has wound back their requirements. But if you're in the healthcare, if you're doing any healthcare type of work, it is still a live issue for work health and safety, because there's that duty to others, i.e. the patients or the aged care, often the people living in the residences, who are particularly vulnerable to infection. So COVID-19 is still a live work health and safety issue for those very much at risk associations. The governments, state and federal, have been pushing very much also bullying and sexual harassment and discrimination as work health and safety issues. So recent amendments federally, and I think it's passing through to the states as well, where that's going to that you could be prosecuted. You already could be done for bullying, but for sexual harassment and discrimination in the workplace. That's in addition to their own legislation for sexual harassment and discrimination. In Queensland, it's the Anti-Discrimination Act, and federally there's sexual discrimination and racial discrimination legislation. And the last one I wanted to raise was very quickly, it's becoming a hot topic amongst us in work health and safety, is vicarious trauma, where employers or PCBUs are being looked at very closely for not considering how their workers may be affected by traumatic events that they witness or have to deal with as part of their businesses. So I'm seeing that particularly in the healthcare sphere, but also in the emergency services sphere. Very much, it's a hot topic down in New South Wales. We've had it up in Queensland, where the courts have treated it a little bit more warily, because I said that's an inherent part of your job. But certainly vicarious trauma, where people are mentally scarred from what they see happen to others, is becoming a very, very lively topic of discussion, and I would expect that's going to be an area of development in the years to come. So we know, firstly, who owes the duties. We know very broadly what the duties are, that is to act reasonably practicably to avoid injuries. So what is reasonably practicable? Because you might be thinking, well, bloody hell, how the hell am I ever going to satisfy any of these obligations? It just seems like an impossible task. So the legislation acknowledges that you're not going to be perfect. It's not going to be, you're not going to avoid accidents. But they all say that reasonably practicable means you've done everything that a reasonable man would expect you to do, or reasonable woman would expect you to do. So it's an objective test. It's not your personal opinion of what you need to do. It's not the personal opinion of the poor victim of the activity. It's what someone standing off to the side looking at what was done would say, well, that seemed to be, without the benefit of hindsight, or being able to predict that the accident's going to happen, that seemed to be, everything that could reasonably be expected to be done. As I said, it's non-delegable, so that means you can't shift it to responsibility to someone else, like an external provider. You can't have willful ignorance. And it looks at what was the situation at the time the event occurred. It doesn't look at what happens in the future. So you can't look back at things with hindsight, but you got to put yourself in the shoes of the reasonable person as at the time the event occurred. Could someone have known that this accident was going to occur, and why would they have known that, and what steps were reasonably available to them at the time? So those of you who are involved in work health and safety might be aware that there's a matrix that we use, where along the top of the matrix you rate from 1 to 5 the degree of harm that could be caused by an event. Then down the side of the matrix you rate from 1 to 5 the likelihood of the risk occurring. So you might have something that's got a very, rating 1, very high risk of something occurring, but if it occurs, it's going to cause minimal injury. Conversely, you might have something that's going to be highly, highly unlikely to occur, but if it does occur, it's going to kill someone. So you have that sort of and everything in between. So what that matrix does is then, from those two sliding scales, rates all those permutations as to high risk, medium risk, or low risk. Because nothing's ever no risk, but if it's low risk, then your requirements to take steps is lower than would be, say, a high risk. So if you've got a high risk of injury and a high likelihood that it's going to occur, you've almost got to cease the activity completely if you can't make it free from harm. Conversely, if you've got something that's going to be so rare, it's going to happen once in a blue moon. I've got a matter at the moment where a workplace has been operating a machine for 50 years and has never had an accident, and has been told now to put a special wire fence around the machine to prevent people being injured. And we've said, well, the cost of this wire fence will exceed the reasonableness of an accident occurring, because no one ever goes near that machine in any event. So we're involved in the argument about that the likelihood of it occurring is a rating down the bottom at 5, even though the risk of injury would be at the top at a 1. And that brings into the question, which we've got in that case, of cost of safety measures. So that you're not required to gold plate everything, but you are required to spend a reasonable amount of money if the risk is sufficiently severe. Which again is a very, very, very quick discussion on something that's far more nuanced. But we've only got time to alert you to that matrix at this stage. So what is reasonably practicable? Examples are, and these are particularly things that work health and safety will always look at when they come to investigate an accident. They look at things like what's called standard operating procedures, or SOPs, the manuals that you might use for equipment, codes of practices. Pretty much anything that's going to show paper exists that tells people what to do. Then they're going to look at the paper that shows that the people actually were told what to do. So what are the records of training and refresher training? What is the paper trail that shows that they were reminded what to do? That is, so not only that there's a method of doing it, they're told what to do, they're reminded what to do, and they actually did it. That level of record keeping all the way through is what will discharge for reasonably practicable. So if I work out that something's an unsafe practice, I work out a solution in the SOP. I make sure that everyone's trained in the SOP before they use that piece of equipment. I then make sure that they're reminded to check that with refresher training. And then they actually do it either by way of risk assessments before they do the tasks, or they do what's called a take 5, which is you stop before you do the job. You make sure you've kept an eye on things, and then you've identified the risks, and then you go and do the job. Toolbox talks is what we have in the industry, where there's once a month or once a week, a meeting between the workers to go through what are the live work health and safety issues, etc. But you've got to have this chain of paper. You just can't have the manual sitting in a shed or a cupboard somewhere and can't prove that anyone's ever read it. You just can't prove that everyone's been trained in something, but then prove that they've never been reminded of what to do. You can't prove that everyone's been trained in what to do and there's a manual there, but you can't prove that they actually did it on the day. You must have paperwork all the way through. And this is what work health and safety is going to look at when they come out if there's an accident that occurs, which is brings us to, as I said, when things go badly for people. This is the scary part of CLEs that lawyers always do, where they tell you this is why you need a lawyer when things go wrong. And I hate to say it, but this is the things you need to do. And I've tried to set out what you need to do when things go wrong, because you actually do need lawyers, because there are very, very, very serious consequences if there's an event that has caused death or injury. Looking at the first response scenario. So an accident's occurred, someone's been injured, or even in some cases not injured, but there's been what's called a dangerous incident. So a dangerous incident will be things normally involving explosions or noxious gases or electricity running wild, or that there's been someone's fallen off the side of the building, even if they've miraculously not been hurt, or there's been a serious plant malfunction where there could have been a disaster and there wasn't. So it's not just because someone gets killed or requires hospitalisation that you need to tell work health and safety, but it might be as I said, dangerous incident. If any of those occur, so someone's obviously killed, or if it's serious, So serious means they've had, the ambulance has had to take them away. Or alternately, if the ambulance didn't take them away, you find out the next day that actually that something's occurred that's required hospitalisation. That's a notifiable event, or notifiable event, and you've got to send in a notice to Work Health and Safety Queensland to say, terribly sorry, but something's just happened at our workplace. Here are all the details, and that then sets the alarm going off at Work Health and Safety to come out and investigate what's gone on. If a notifiable event an incident has occurred, you as a PCBU have an obligation to preserve the site. You just can't go and clean it all up and whilst the investigators are coming out, they need to see it in the form it was at, as much as possible at the time of the incident, because they've got to carry out a forensic examination of all the evidence. If you go and clean it away, you're depriving them of that opportunity to work out what actually occurred. Once you give notice of a notifiable incident, and provided that the Work Health and Safety agree that yes, this is a serious event, they will send out investigators on the day, normally within a couple of hours of the event occurring. It's really a question of how much they've got, how many bodies they've got to be able to send out to you at the time. But they will pretty much the same day, they'll come out to the place where the event occurs. They will normally lock down everything that occurs, everything that's happening in that place, so that they can maintain the scene in a pristine form. They will what's called tag out equipment, so that they'll say, do not use this, do not touch this. You've got to keep it to the side. Or sometimes they even just take the equipment and confiscate it themselves. They're not confiscating it to take it away from you forever. They're just confiscating it so they can go off and look at it and do tests of their own on it, or at least take it out of circulation so it's not going to hurt other people. So once you send the notifiable notice of notifiable incident, you can expect to get a visit from the inspectors or the investigators within a matter of hours, if not an hour. As lawyers, we highly, 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 highly recommend that you notify your lawyers as soon as a serious incident occurs. So when you're notifying Work Health and Safety, also notify the lawyers. I often get told 2 days after the event, because the investigators have come out and started tagging out or confiscating material on them, and the business is, alarmed that this has occurred. What they should have done was to notify me straight away at the same time they notified the investigators, so that I can be out, or I, being generic lawyer, the lawyer can come out and start interviewing your people straight away and try and get to the bottom of it. That's not to block the investigation, it's rather to get ahead of the curve, so you know exactly what you're facing, as opposed to getting surprised by the investigators and feeling alarmed because you weren't aware that this is what was going to happen. Now, the benefits of getting lawyers involved early are a couple. One is we have a thing called legal professional privilege. So whatever you tell a lawyer that information can't be used by the investigators by asking the lawyer, what were you told? So you can be full and frank and open with us. I'll come to later on, we get asked by the investigators, but whatever you tell us, we keep it within a box, and no one else can know what's been told to us. So that the purpose of that is so you can be full and frank and say, oh, well, actually we stuffed up here because of this. That allows us to then give you legal advice as to what to do. The other thing is lawyers are great at hoovering up evidence. So we get all together all the documents that might be relevant, and we'll ask you for the documents that will be relevant. And so that way you're ahead of the curve. So when the investigators come out and you say, well, here's all the stuff that we say is on point. It's not for concealing documents, it's for getting everything together in an orderly fashion. We can also take contemporaneous statements. So that means you grab the people on the spot who are relevant and you start taking record of their evidence. This does two things. It stops them saying, oh, I forget later on when you interview them a week later, because it's amazing how people can start forgetting things after a week, or they'll starting reconstructing things because they don't really want to face what the real consequences were. or you get people who may not have been involved but get told by other people what may have occurred. By lawyers, and again, we're very good at this sort of thing, by us cutting through to getting the actual people's memories straight away while they're fresh, you got your best chance to preserve your own evidence, even if it might hurt you, but at least you know it's going to, what the evidence is, as opposed to people trying to make up stuff later on, either because they've got a sense of trying to help the company out, or they've got a sense of trying to exonerate themselves from any ill effects. And the other benefit of the lawyers is we act as like a cushion between yourself and the investigators. So you don't have to worry about the hassle so much of being chased up the investigators, and the investigators are much more polite, shall we say, when they're dealing with the lawyers as opposed to dealing with the businesses themselves, the PCBUs. They can be a little bit more harsh in demanding things, whereas with us, they know that we know what the law is and we can sort of push back on them. Now, that's the initial phase where they all come roaring out with the sirens blazing. What normally happens in an investigation, if there's an incident, you'll have, within the first couple of days, there'll be a big rush to gather evidence. They'll then take that evidence off. The investigators will then take the evidence off and read through it, and that can take about a week or 2 weeks. After that, they'll then send a series of questions to the organisation, asking them for documents or for identification of potential witnesses, or for things like standard operating procedures, manuals, records of training, etc. All that document trail that I spoke about before. They will then call people in ask people for informal interviews. And I'll come to that in a second, but if you're not going to have an informal interview, so they'll ask for formal interviews. They might look and say, we're not happy with this particular setup. We think you need to take steps to minimise risk. So they'll issue either an improvement notice or even a prohibition notice. So a prohibition notice means do not, under any circumstances, ever use this again until we say you can. Whereas an improvement notice means you'll be able to use this again once you show that you've actually fixed the problem. So prohibition notices are much worse than improvement notices. But going back to the interview part of it, so there's power under the legislation for the investigators to call people in for interviews. If you get called in for a formal interview, you're required to answer all questions that are put to you. You can't refuse to answer a question on the grounds of self-incrimination. So that's different from the criminal law, where you can say, I claim privilege and refuse to answer the question on the grounds I might incriminate myself. You still have to answer the question in a formal interview, but the answer that you give can't be used against you personally if there's a prosecution later on. So what that means is it can't be taken as an admission that you did something wrong. It can be used against the PCBU because that's a different entity to the witness themselves. It can also, the information that you give can also be used to make further inquiries that will lead to the same result, that might lead to your prosecution, but your statements can't be used as an admission against yourself. The problem that I often face is that people who are aware of that then try to make up stuff. And I then have to warn them, if you make a false or misleading statement to try and protect yourself or the company or the PCBU, then you can be prosecuted separately for making that false or misleading statement, and they'll also find out the truth anyway. So as bad as it might seem, it's still a better course of action to make the admissions about things in a formal interview. Now, if you do an informal interview, that is, do you just want to have a quick chat, particularly on the day, to have an informal interview, if you make an admission against your own interests, then that admission is admissible. So that's why lawyers will often say, if you get asked for an informal interview, say, thanks, but no thanks, but I will attend a formal interview. So you at least got some protection. But if you go and have an informal interview with the investigators, then whatever you say, it's open slather as to how they might use it. And very quickly, because looking at the time, assuming that they've done the investigation, normally after 3 months, they've gathered all the documents, They have spoken to all the witnesses they want to speak to. The investigators will then prepare a brief and send it to their Crown prosecutor to decide whether or not there should be someone who could be prosecuted for the accident. That process can take like 18 months from experience, but there's a 2-year time period within which the Work Health and Safety Queensland must decide if they're going to prosecute someone or not. I've had cases where, because of poor resourcing, that time limit has expired, and you end up with no one being prosecuted because they've just run out of time. It's fairly rare, but it can happen. So once the accident occurs, you've got 2 years clicking on the clock. So you often find that person get prosecuted, 7 days before the 2 years expires. It is a criminal prosecution, so that people have got to prove beyond reasonable doubt that certain things occurred, which is more than just a civil onus, which is more than 50% on the balance of probabilities. But having said that, it's because reasonable practicable is a fairly onerous duty. If an accident occurs, the general rule of thumb is that you're pushing it uphill to prove that you didn't cause the accident. So it's not a reversed onus, but it's very much the case that you've got to show that you took the reasonable practicable steps. If there is a prosecution, they'll pick a category of injury that they'll be pursuing. So category 1 means that you've actually caused death or serious injury, and there's been reckless behaviour. Reckless means not just that you stuffed up; it means that you knew that there was a risk and you went ahead regardless. You were such disregard of the risk as to cause a hazard to others. So it involves a certain degree of knowledge and willfulness. So it only apply in the most serious categories of cases. Category 2 is where you've stuffed up and someone's died or had serious injury. You don't have to prove that you're willful or you're careless or reckless in that behaviour. You just have to show that you stuffed up and you didn't do everything that was reasonably practicable. The last category is that you stuffed up regardless of whether someone was hurt or not. So that will be often the cases where there's explosions or there's release of gases or there's electrical issues where someone was not injured. But it was a fairly serious event that caused a lot of alarm, and you should have done better to fix the problem. As you can expect, the penalties differ significantly from category 1 down to category 3. And the penalties that they'll look at what were the extent of the work that you did beforehand to try and avoid risks. What remedial steps did you do after the event to fix up the problem? And what was your record of accidents in the past? So there's a whole lot of issues that go into the considerations of how much the penalties might be. But essentially, if you get hit with a category 1, that is bad news. If you get hit with a category 3, it's not great news, but it's not the end of the world, so to speak. And I'm lastly going to cover industrial manslaughter, because that's been a live issue for us in the workplace health and safety sphere, in the last 5 years. Queensland has industrial manslaughter in the work health and safety legislation. It's not part of the national scheme, but slowly states have been introducing it. But for your purposes, Queensland has it. And that means that in addition to those category 1, 2, and 3, there is a much more serious category. If the person is killed from a workplace accident, it can be brought against not just the corporation, but you bring against people who are essentially officers, so the executive officers, senior officers, holding people liable to the point where they can be not just fined, because category 1, 2, and 3 are predominantly fines, but this actually allows people to be put in jail for whether it's workplace deaths. Now that's very serious stuff. So you'll see that they've excluded volunteers because they don't want to penalise people who were with this industrial manslaughter. That volunteers can still be hit with category 1, 2, and 3, but not put in jail volunteers who have done things on a philanthropic basis. If you're not a volunteer, that is, you're paid to do the work, you can be hit with this provision. And as I got down there, obviously got to have someone killed. Now they'll look at the person's conduct and they'll look at whether the conduct was negligent. Negligence is not reckless. That is, reckless is knowing something's bad and you went ahead regardless. Negligent means that you had a duty, you know the scope of the duty, and you failed to perform that duty to the extent of where there's a foreseeable risk and you fail to take proper steps to avoid it. It's a step above reasonably practicable, but it's a step below reckless. So there is a certain extent that you have to have the knowledge this might have caused death or injury, but it's not so bad as to say I went ahead regardless. Nevertheless, because industrial manslaughter is so heavy with the potential risk of jailing, the courts are very, very reluctant to find against a person unless there is some element that the person has just been, for want of a better word, stupid in performing the acts that have caused the death of a person, so that they will say you were more than just a little bit careless. You were so careless that you should have known better than what you did. So with that frightening prospect of going to jail, which has occurred in Queensland, there's been the first conviction was, remembering last year, although it could have been early this year. The dates sort of blur a bit because of the COVID period, but they are sort of looking at the prosecutions. You find it mostly in the construction industry with people who get crushed. I know one conviction recently was for a owner of a forklift who had the worker standing on the tines of the forklift as it was carrying a large container, and the forklift overturned because of the weight on the tines, and the container fell off and crushed the worker. And the forklift operator did not have a license, and the forklift operator did not check the appropriateness of the weight of lifting the container of the tines, etc., and just told the bloke to jump on the end anyway, just to steady a multiple ton container when the worker would have no capacity whatsoever to do anything if that weight started shifting. So you can see that it's more than just, I was driving and I was a little bit careless as I went around the corner and the container fell off and hit a worker standing nearby. I've created a hazardous situation. I've gone ahead and progressed with that hazardous situation when I should have realised, if I stopped for a second, that this was not a great idea. And I've gone ahead regardless, and this person's actually suffered the injury from what should have been foreseeable way back when I started the whole process, which goes back to what I was talking about, risk assessments and take fives, etc. So that completes my quick cook's tour of the work health and safety. I've got about 4-ish minutes. If anyone's got any questions, if you want to type the questions or if you want to verbalize them over the system, I'm more than happy to take them. Again, I appreciate that I talk in generalities, but if anyone's got any questions about what I've said, please speak up. Anyone?